Chapter 16. Domicil of Particular Persons. Public 153 Officers. SS 307. The domicile of one class of public servants, namely soldiers and sailors in the War Marine Service, has already been considered. Another class, to wit, ambassadors and consuls, will hereafter be considered by itself. It is necessary, however, here to treat in a general way of persons in public civil office or employment, and concerning them several general rules may be laid down. SS 308. Life Functionaries. First, if in office the duties of which are to be performed at a particular place be irrevocably conferred upon a person for life, the law fixes his domicile at the place where the functions are to be performed. In such case the law presumes animus maenendi, and this is so no matter whether the official constantly reside at the place or not, and even if he has a habitation elsewhere. This, however, must not be understood to apply to an office whose duties require only the occasional presence, but to one whose duties require substantially constant presence. Denisart, who has treated of the domicile of public officers at unusual length, says, those who are attached to a residence by a perpetual title are considered to be domiciled at the place of their functions, whatever place of abode they may have elsewhere, even when this abode has all the characteristics of their principal habitation. One may not attribute to them an intention contrary to duty. Thus, a magistrate is always presumed to be domiciled in the place where he exercises his functions. He includes also in the same category bishops, cures, canons, and other ecclesiastics subject to residence. The Code Civil I provides, the acceptance of functions conferred for life will import immediate translation of the domicile of the functionary into the place where he ought to exercise such functions. Tribune Muracault, in his speech to the tribunate, explains this provision thus: the law ought to presume that the citizen who accepts perpetual functions wishes to devote himself resolutely to them, to perform his duties with exactness, to establish himself for that purpose at the place of their exercise, to live at least principally in that place. It cannot admit any other presumption with regard to the life functionary. To the extent of intending to give countenance to a different course of conduct, it would be a calumny upon it to suppose of it such inconsequence or such feebleness. SS 309. ID. There is some difference of opinion as to the point of time at which the law ascribes to a life functionary a domicile at the place where he is required to exercise his functions. Pothery fixes it at the time of arrival, but later French jurists, considering the language of the article definitive, hold that the translation of domicile results solely and immediately from the acceptance, that is to say, from the taking of the oath. And this is the generally received opinion, notwithstanding the possibility of such anomalous results as that pointed out by Villette. He supposes the case of a functionary dying at Paris after having accepted functions from which he is not removable, and taken the oath, and says it is certainly strange that his succession should be opened at the extremity of France, maybe in a place where he has never appeared and where is not found any paper or document relative to his succession. But in the absence of any positive law on the subject, the doctrine of Pothier seems to be the only safe one. SS 310. Holders of temporary or revocable offices or employments. Second, a public office or employment of a temporary or revocable character does not fix the domicile of the holder at the place where its duties are to be performed, even though he may reside there in the performance of them for a long time, but, on the contrary, he is presumed to retain his former domicile. In the case of a temporary office or employment there can be no difficulty, inasmuch as temporary residence, whatever may be its cause or purpose, cannot confer domicile. But with regard to an office or employment which, though granted for an indefinite time, is in its nature revocable, the rule is the same. In such case the residence, however long it may last, being constantly liable to be ended, and being referable solely to the duties of the office or employment, no inference can be drawn from it of such animus maenendi as is necessary for the establishment of domicile, especially national or quasi-national domicile, and upon the principle that domicile once shown to exist remains until it is shown to have been changed, the person retains the domicile which he had when he entered upon such office or employment, unless other circumstances than mere residence appear. In general, it may be said that the official in such cases is presumed to intend to return to his former place of abode whenever his tenure of office is at an end. But even if it appear that he intends in such event to settle in a third place, the result would be the same. SS 311, ID, Continental Authorities. Zandris says, Andreas Alciatus interrogatus responded, non contrasis domicilium, cum ob causam prefecturi vel alium, eo loci commoritor et finito officio praesimitur redituris ad locum sui domicilii, quam sententiam verum es existimo, nisi alii concurrent conjecturi, ex quibus manifestum sit, prius domicilium est relictum. Si enim res, quas alibi passae bat, venditur et cum familia in eam locum demigraver et habitet, sani bidem domicilium contrasis meo judicio viter, per qua tradita sunt supra. Secis viro si alibi bona, pre certum immobilia retinis et ibidem instructus esset, per qui dixi supra. Denisart says, it is otherwise concerning those who, instead of a perpetual title, have only momentary occupation in the place which they inhabit. Their habitation is regarded as a consequence of their employment, of their business, or their occupation. It is presumed that they have always preserved the intention of returning to their former domicile at the time when their business shall be finished, even when they have not preserved a dwelling house there. When, on the contrary, they have at the place whence their business has attracted them a considerable dwelling house, all their movables, their domestic servants, and all that which may contribute to the convenience of life, they are considered to have retained their former domicile. Denisart cites a number of cases which have been decided by the French courts, one of special interest being that of Sieur Garangeau, who was born at Paris, but died at the age of 94 years, in the exercise of the office of Director of the Fortifications in Brittany, where he had resided 64 years, namely 9 years at Brest and 55 years at St. Malo, dying at the latter place. Notwithstanding this long residence, he was presumed to be domiciled at Paris, where he was born. The French code provides that the citizen called to a public function, temporary or revocable, shall preserve the domicile which he already had, if he has not manifested any contrary intention. SS 312, ID, English cases. In England and America the doctrine is well settled as above stated. In Attorney General v. Pottinger, the Court of Exchequer held that one who resides in a colony as governor, to which position he has been appointed for a fixed time, does not thereby gain a domicile there. Attorney General v. Rowe, in the same court, furnishes an example of a revocable office. R., whose domicile of origin was English, was appointed Chief Justice of Ceylon during the pleasure of the Crown. His commission contained a clause obliging him to actual residence within the said island, and to execute the said office in his person, and in consequence of such appointment he went to Ceylon, taking with him his family, and continued to reside there in the discharge of his official duties until his death, about 4 years afterwards. Under these circumstances, his domicile was held to have continued up to the time of his death. While the B said the testator went as a judge to Ceylon, but the case is devoid of any expressions or act of his from which the court can draw a conclusion that he intended to make that place his domicile. The fact that he left his library in England points the other way. The onus is on those who wish to establish a foreign domicile, and they have nothing to rely upon but the isolated fact that the testator accepted a judicial office and went to Ceylon. England was his domicile of origin. He had lived there all his life, and he left on his appointment as Chief Justice of Ceylon. There was nothing permanent in the nature of that appointment, nothing inconsistent with his domicile of origin. If regarded strictly, and without the knowledge which we extrajudicially possess, it was a colonial office during the pleasure of the Crown, and therefore of a temporary nature. If regarded with the light of that knowledge, it was an office to be enjoyed for a limited time, after which a pension would probably have been granted to him. It is, therefore, a case of residence adopted for a special and temporary purpose, and for a time which, though not definitely fixed, was not likely to be indefinitely prolonged. Such a residence does not, in my opinion, of itself create a domicile, though possibly a domicile might emanate from such a residence, if protracted for a considerable time. In this case there was no such lapse of time, and therefore, in my opinion, no new domicile was acquired. In Douglas v. Douglas, Wickens v. C. held that one whose domicile of origin was Scotch did not gain an English domicile by 10 years' residence in London as a clerk in the Home Office, there appearing no evidence of any intention to settle finally and for life in England. SS 313, ID, American Cases. In Yankee v. State, it was held that an assistant doorkeeper of the United States House of Representatives does not, by reason of his presence at Washington during the sittings of Congress, lose the legal residence which he had at the time of his appointment. In Dauphin County v. Banks, it was held that the Auditor General of Pennsylvania, whose official tenure was for 3 years, did not by virtue of his office acquire a domicile at Harrisburg, the seat of government, although the law required his office to be kept and his official duties to be performed there. Instances of revocable offices are furnished in the cases in which the question of the domicile of clerks and other employees in the government departments at Washington has been discussed. It has been uniformly held that such persons do not acquire a domicile thereby their presence in discharge of their official duties, nor do they lose thereby the domicile which they had at the time of their appointment. SS 314. Public officer may acquire domicile where the duties of his office are to be performed. Third, there is nothing in the fact of holding a public office or employment which prevents the holder from acquiring a domicile at the place where his duties are performed. He may acquire a domicile there if he sees fit to do so, and whether he does so or not is to be determined in substantially the same manner and by the same methods of proof as in other cases, except that in his case no inference is to be drawn from length of residence, nor, at least generally, from the presence of his wife and family, nor from such similar circumstances as usually accompany residence, whether temporary or permanent. Article 106 of the French Code provides for cases of this kind by the exception, if he has not manifested any contrary intention. SS 315. Public officer remaining after expiration of office. If a person who has come to reside in a place where his official duties are performed remains there after his term of office has expired, or his appointment has been revoked, such continued residence is evidence of the acquisition of domicile there. SS 316. American State Constitutions. Many of the state constitutions contain, with reference to voting, a provision that no person shall be deemed to have gained a residence by reason of his presence, or lost it by reason of his absence, while employed in the service, either civil or military, of this state or of the United States. This provision has been held to be declaratory of the unwritten law, and not to alter it, in several cases in which the employment was temporary and revocable. What effect it might have upon the case of one who held a life office seems not to have been discussed.